Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about the common but sometimes complicated trustee succession designations in a trust. All right, there are some trusts that go on for many, many decades. I'm going to give you a couple of examples of those in a minute. So when someone sets up a trust that's going to go on for many years, decades, or even longer, there's some provisions that become really important in that trust. Provisions like who's going to be the trustee? Who's going to be the alternate trustee? Who's going to be the alternate after that? Is there going to be co-trustees? If so, what are their powers? How does a trustee get removed? What if there's a vacancy in the office of the trustee? All these things become real important. It can seem overwhelming. Let me give you a couple of examples and then we'll apply what the decisions typically are. All right, so a couple of circumstances where trusts may go on for many, many years, decades. Let's say you have some parents of minor children and the parents bought a couple of $1 million of life insurance. They want to provide for their children should the parents pass away. Their children are small, maybe 10, 8, and 6, and the parents set things up so if the parents pass away, all that life insurance money goes into a trust for the children instead of being dumped into their lap when they're 18. Or maybe a grandfather has a grandson and he wants to establish a trust for his grandson. He may be thinking something like, you know what, this grandson of mine, he's the apple of my eye. He goes fishing with me. I want my grandson to have opportunities that I didn't have. So I'm going to leave him X dollars or a percentage of my estate. And let's say that turns out to be $750,000, but grandfather is thinking one thing and one thing only. I am not going to let my grandson get that in one big chunk. I'm going to insist that that he work and go to college and that he get a job and he not be spoiled. I want to make sure he doesn't spend this money on things that he shouldn't be spending it on. And I certainly don't want to dump a bunch of money in his lap where he may get into a drug problem or alcohol problem. And then what I try to do to help him, I ruin his life. That's not going to happen. So the grandfather says, I'm gonna leave this, or I'm gonna give this, I'm gonna leave it when I pass away in a trust for my grandson. When the grandfather does that, he's got some decisions to make. Decisions like, how long will this trust last? And the grandfather's saying, I got no idea how my grandson's gonna turn out. He's a great kid, but he's 10 years old. A lot can happen. I don't know who he's gonna hang out with. He could make some bad decisions. So I want this trust really to last for my grandson's lifetime. That means the trust could last, he's 10. So the trust could last for 70 or 80 years, maybe even more. But so he makes that decision to make the trust last for the grandson's lifetime. Another decision the grandfather may make is, I want trust principal. I want the trustee of the trust to have the discretion to give principal to or for my grandson's health, education, maintenance, or support. The typical HEMS standard, HEMS, health, education, maintenance, or support. I've talked a lot in other videos about this HEMS standard, and that's very common. So those are some of the decisions the grandfather has to make, but he's got to make some other decisions. And this is where it can get a little bit tricky and a little bit complicated, and we want to make sure grandpa doesn't get overwhelmed when he's making these decisions. So we got to say, all right, grandpa, we got to make decisions about trustee and successor trustees. So one of the first decisions is, should grandpa name a corporate trustee or should he name an individual trustee? Well, I was talking last week to someone who worked for a corporate trustee, and this person told me, Paul, I work for a corporate trustee, and I'm just letting you know that the corporate trustee that I work for, they will not accept the position as trustee if they're designated in a trust unless the trust has at least $10 million of investable assets. Well, this is going to be, let's call it $750,000. So that takes the whole corporate trustee out of the equation. Now, if there's a corporate trustee out there watching this video and you accept positions of trustee when a trust has investable assets of maybe $500,000 or $750,000, put something in the comments below, but I think I'm going to hear crickets. So corporate trustee, out of the question. Individual trustee, who should that individual trustee? Grandpa may say, you know what? My nephew, he'd be perfect. He has a good relationship with my grandson. When I die and leave this to my grandson, I want my nephew to be the trustee. And so grandfather might be asked, what if nephew can't do it? Well, then I want my niece to do it. What if niece can't do it? I want my second cousin to do it. So maybe somebody names a backup and then a backup to the backup and goes on from there. Now, here's some other questions. Sometimes grandpa may want co-trustees. He might be thinking to himself, I don't want one person to have the pressure of making these determinations of when my grandson can have money. I want 3 people to do it. So when there's co-trustees, grandpa has to decide, if they need to do something, can they act by a majority? 2 out of the 3 are necessary for the trustees to take an action, or does it have to be unanimous? And then what about when a trustee one of those co-trustees needs to be replaced? So there's 3 trustees, one of them can't do it. Does that one get replaced by somebody else, or do the remaining co-trustees serve by themselves? And by the way, when grandfather did designate a nephew, then niece, then second cousin, grandpa, what if nephew decides to resign and you really think nephew is a great guy? Do you want to give nephew the power to designate who that next trustee would be? Or do you want it to just automatically go to niece? And in that case, he may say, yeah, I really, really, really trust my nephew. So if he's going to resign as trustee, I want him to be able to pick who the next trustee would be for my grandson. So that brings up another kind of layer of complexity. And then there's the whole, what if a trustee becomes incapacitated and they can no longer serve as trustee? They get sick, they die, they get old, they get Alzheimer's, they have a stroke. Well, what does incapacitated mean that would cause that trustee to no longer be the trustee? Who determines when a trustee is incapacitated and can't serve anymore? Is it through a doctor's statement? Is it 2 doctor's statements? If a trust has multiple beneficiaries, can the beneficiaries declare that a trustee is incapacitated and must resign? And if so, is it all of the beneficiaries must do that together, or majority of the beneficiaries? Is it going to require a court to determine that a trustee is incapacitated and they can't serve anymore? So there's all those questions involved. And then there's in the event of a vacancy in the office of trustee, how will a trustee be determined? So grandfather designated nephew first, then niece, then second cousin. What if none of them are around to do it? There's a vacancy in the office of trustee. Many trusts out there say in the event of a vacancy in the office of the trustee, a corporate trustee will be appointed, and that corporate trustee must have capital requirements of $100 million or whatever. But we found out earlier that many corporate trustees aren't going to be willing to accept the position as trustee unless there's a whole lot of money that they can manage and to justify their trustee compensation. So then in the event of a vacancy in the office of trustee, who gets appointed to be a trustee? Is it an attorney that must get appointed to be the trustee? Well, attorneys are good at being attorneys, but they're not necessarily good at being trustees. Should it be an accountant? Accountants are good at accounting, but many accountants aren't good at serving as a trustee. So all of these decisions, getting kind of exhausting here, all of these decisions, when presented to someone who is setting up a trust, can appear really complicated. In fact, sometimes when faced with all of these overwhelming decisions, the person who is considering setting up the trust will just punt and say, you know what, there's just too much stuff here, too many decisions that have to be made. I don't have that many people that I can designate. I tell you what, let's not make this trust for my grandson's lifetime, because this stuff gets so complicated. You know what? When he's 21, he can have it. Or when he's 25, he can have it. Or when he graduates from college, he can have it. So sometimes parents will shift course when presented with too many overwhelming questions that have to be answered. So, but it is, that's the challenge of creating a trust that may be in effect for many, many decades to come. You have to provide for the fact that people that you designate to fill certain roles are not going to be able to fill those roles in the future. And so you have to have a succession for how all of that gets taken care of. So keep in mind, when setting up a trust, the trustee successor designation is an important part of establishing things. It may not appear too important now, but it could be really critical 20, 30, 40 years from now. So hope that helps. Give this video a big thumbs up. If you haven't subscribed already, make sure you do so. Hit the notification bell so you don't miss anything, and we'll see you next time.